Welcome everyone back to another live episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I am Senior Staff Attorney Susan Ingalls here with our producer Kenneth Elliott, and you are viewing live employment law attorney Jack Cahoon of the Burnett Schutt Law Firm here in South Carolina. Jack, would mention was formerly here at South Carolina Legal Services and was our employment law unit head. So it's definitely an area that he has a lot of knowledge in. And today we are delighted to have Jack back to join us to talk about an important issue that we see here at Legal Services. And Jack, I'm sure you do too, claims under the South Carolina Payment of Wages Act. So welcome, Jack. But before we get started, we do want to remind you, our viewers, that this is not legal advice. It's just general information for the public. If you do need the help of a lawyer, call our intake line here at South Carolina Legal Services or apply online. That information will be provided at the end of Jack's presentation today. And also, as a reminder, all of our episodes are posted by producer Kenneth Elliott to the Level Up Law playlist on our YouTube channel. So you can go there, share the video of today's presentation, and while you're there, y'all be sure to give it a thumbs up and also subscribe to our YouTube channel. You can be sure to check out all of our social media channels and get all the up-to-date information that we provide on Level Up Law and all of our other great resources. Those websites and social media handles you can find on the last slide in today's presentation. So Jack, welcome to Level Up Law, and we appreciate you being here. I'm gonna let you get started, but first I do want to show our viewers the slide where they can give us an idea about an episode topic that they might want us to do. This is a QR code where you can send us a request for a particular topic or an idea for a topic for 2023, and we're already getting some ideas from our audience, so we really do appreciate that. Also, we have that QR code on that first slide, and then on the last slide is a way that you can sign up for our newsletter and get even more information that's important to you, our listeners. So without further ado, Jack, I'm going to turn it over to you. Welcome to Level Up Law.
Thank you, Susie. This is a little bit of a virtual homecoming to be back with my friends at South Carolina Legal Services. So I'm happy to be here. I'm an attorney at Burnett Schutt McDaniel Law Firm. We're going to talk today about the South Carolina Payment of Wages Act, which is a great law, a wonderful tool for employees to make sure they get paid what they're owed. And it's fairly straightforward. It's got some wrinkles like all laws do, but we're going to go through it and talk about it. And if you have an issue of getting paid, we're going to talk about what tools there are available to get paid what you're owed. So there are several laws that touch on payment and employees getting paid. We have the South Carolina Payment of Wages Act, which is what we're talking about today. There's a related law called the South Carolina Payment of Post-Termination Claims to Sales Representatives Act. That's a mouthful. That really deals with like commissions for door-to-door salesmen and that sort of thing. And then there's the Fair Labor Standards Act, which deals with overtime and minimum wage, among other things, and that's a federal law. We're not going to get in deep into the Fair Labor Standards Act because it's a pretty complicated topic, but we'll touch on a couple things at the end of this presentation. We're going to be focusing primarily on the Payment of Wages Act, which is a South Carolina law. So the first question with when somebody comes to me about a wage issue is I try to figure out, are they covered by this law? Because the law only covers certain employees. It excludes certain employees. So under the law, employers of domestic labor and private homes are excluded. So, like people, housekeepers who work directly for a homeowner are not covered under this law. And also employers that have fewer than 5 employees at all times during the preceding 12 months are excluded. So this law doesn't work in those two situations. but it does apply in every other situation of employees doing work in South Carolina. So if you've got if you work for an employer that has 5 or more employees and the work is done in South Carolina, then the Payment of Wages Act probably applies. The next question is, what counts as wages? So wages is very broad, and I hate to get into all this legal mumbo jumbo, but essentially it means everything that you're supposed to get paid for your work. And it could be work payment based on a fixed amount or a task. If you're supposed to get paid a certain amount based on tasks that you do, or piecework or commission, or hourly work or salary. It could be any of those situations. And it can include payment for leave, which are due to an employee under any employer policy or employment contract. So it's pretty broad. Now, oftentimes clients that come to me have issues where they're supposed to get reimbursed expenses, and that's usually not going to be considered wages. So like if mileage reimbursement may not be wages, it really becomes a little bit more of a complicated question. It doesn't mean that you can't seek to get reimbursed for mileage or money that you spend out of pocket for your employer, but then we have to get into a little bit more complicated analysis to figure out whether those count as wages or something else. Now, one of the basic parts of this law is, and this is something that many employers don't do right, but one of the most basic parts is that employers are supposed to give every new employee notice in writing at the time of hire of their normal hours and wages agreed upon, the time and place of payment, the deductions that will be made from the wages, such as payments to insurance programs, and then they can provide this notice by posting it in a conspicuous, which means easily visible place in the workplace. So they basically, everyone should get this sort of notice, and it sets out exactly how employees are to get paid, and how and when they're to get paid, and where do they go to pick up their paycheck someplace, or is it going to be direct deposited? All these little details. And probably most significantly for many cases is there has to be notice of any deductions that are going to be taken. So for example, if you work at a restaurant and the restaurant wants to deduct from the paycheck for employees who break dishes, then to do that, the employer has to have provided notice at time of hire, or at least 7 days prior to deducting the wages. That could be something that the employer would do. They can't just all of a sudden say, oh, you broke a dish, you dropped a dish, so I'm taking the cost of that out of your paycheck. That's prohibited unless they very carefully have provided notice to the employees following proper procedure, notice in writing, that could be something that would happen. That's a fairly common scenario that in that particular type of industry, and employers oftentimes mess that up. The other thing that this interacts a little bit with the Fair Labor Standards Act and the issue of whether an employee is being taken below minimum wage through those deductions. So if you have somebody who's entitled to minimum wage and an employer deducts wages, and all of a sudden they're bringing home less than $7.25 an hour because of those deductions, that might be a violation of the South Carolina the Fair Labor Standards Act, which we'll talk about later. So anyway, just keep that in mind. You really should get something in writing indicating what you're to be paid, when you're to be paid, what deductions might be made from your pay, and that should have been given at the time of hire. Now, our State Department of Labor Licensing and Regulation has put together a nice little form that employers can fill out that meets those requirements. So this is available on Department of Labor Licensing and Regulation's website. So if employers use this, they have satisfied the requirements of the Payment of Wages Act to provide that notice. So it's a useful, very useful thing. And we always encourage, for those employers that we talk to, we encourage them to use this form to make sure that they're abiding by this law. Now, there are some other responsibilities employers have under this law. Employers must keep records of the names and addresses of all their employees and the wages paid each payday and deductions made from each payday. They must keep those records for 3 years. So they have to maintain those records. They can't, get rid of them at the end of the year. They have to keep them for 3 years. Every employer has to provide their employees with itemized statements showing gross pay and deductions, right? So, you probably have seen a check stub. Now, most people have to access this through like a payroll service like ADP. So it's important to be able to know how to log in to get this information. And it can be very hard to get it after you're no longer working for the company anymore. But ideally, you should be getting your paycheck stubs or logging in to view your paycheck stubs to make sure all the deductions are correct and that you understand what money's coming out of your paycheck. Now, there's some other limitations on employers. Employers can't post-date checks. They can't give you a check and say, don't cash this until next week. There won't be any money in the account until then. They can't write a bad check, obviously, right? In fact, we've had situations where employers wrote bad checks to their employees, and that's actually a criminal offense, as it would be for an individual to write a bad check with insufficient funds. That's a whole nother legal issue. Employers can't withhold or divert any portion of an employee's wages unless the employer is required to do so by the law, or they've given written notice to the employee of the amount and terms of the deductions, which has to be 7 days in advance written notice, right? So they can't, it's unlawful for the employer to say, hey, you broke a plate, I'm keeping your, I'm taking $20 out of your paycheck, unless they gave that proper notice. Every employer in the state has to pay all wages when due at the time and place designated in the written notice. So that notice I showed you, or something like it, they got to follow it. And is the moment that they are issuing a paycheck late, or saying, hey, you're gonna have to come pick up your paycheck from some different place than was agreed to, those situations are when there may be a violation of the Payment of Wages Act. So when employees are separated from their jobs, whether it's voluntary resignation or termination, then the employer must pay them within 48 hours of the separation, or the next regular payday, which may not exceed 30 days. So let's go over that again. So if you were separated from your job and you're owed money, let's say you're owed your last paycheck, or you're owed annual leave that you under the employer policy is supposed to be paid out. In that circumstance, the employer has to pay it by the next regular payday, basically, which cannot be further out than 30 days. And at the point that they pay late, they're in violation of the Payment of Wages Act. Any changes in these terms must be made in writing at least 7 calendar days before they become effective. So, and this doesn't apply to wage increases. So, but let's say you're given a written, let's say your employer says, hey, I'm not happy with you, so I'm cutting your pay. And, and they say this, but don't give you anything in writing saying they're doing this. Well, that's a violation. Especially if they're going back and saying, hey, I'm not happy with the work you did over this past pay period, so I'm cutting your pay. If they didn't have anything if they hadn't given you anything in writing indicating they're going to do that, then they're in violation of the Payment of Wages Act. Because they can only do things, they can only reduce pay going forward 7 days out, at least 7 days out, by providing that written notice. So that's where many employers are in violation. Or at least those are the violations we frequently see, is where there's been changes to the payment, what they want to pay the employee. They didn't provide that notice, and by doing so, they've violated the law. Now, what do you do when you're owed money and you're not getting paid? Well, you've got a couple of options. One is you can seek administrative enforcement through South Carolina's Labor Licensing and Regulation Department, a part of that agency called the Wages and Child Labor Office. And they have some ability to try to encourage an employer to pay. Now, that ability is somewhat limited because LLR is only authorized by law to impose a $100 penalty for each violation, and they cannot order the employer to pay. So, many employers don't want to get a citation against them. It looks bad. It certainly could be a problem, especially if they, get government contracts and things like that to have been cited. But really, LLR's ability to help you get paid can be somewhat limited, but it's still there. There's a link here that you can use to make a complaint of unpaid wages. There's no requirement that you make a complaint to LLR before filing a lawsuit. So this is not something anyone has to do before filing a lawsuit. One of the useful things, there's a couple of useful aspects of this though. One is, sometimes employers actually pay when they are, sometimes they'll actually make payment when they get contacted by the LLR. So it can be a way to resolve the problem somewhat quickly without a lawsuit. But the other benefit is that the investigators at LLR will basically reach out to the employer and start gathering records, and they can get a copy of, the terms and conditions of employment. They can, get the employer to respond to questions that they ask, and get other copies of timesheets and things like that. And basically, after their investigation is done, you can go in and easily ask for a copy of that investigative file and get it. And it's very helpful to have that at the beginning of a lawsuit, because basically some of the work's already been done by the Department of Labor Licensing and Regulation. So, that can be beneficial sometimes. But as I said, it's good to have realistic expectations that this agency really doesn't have as strong enforcement abilities as people would think. The other avenue to seek recovery is to actually bring a case in court, right? So that's and actually one of the really good thing about this law is it's got some teeth to it for bringing claims in court. If you have to file a lawsuit, the judge may, and I say may because this is not automatic, the judge may decide to award you 3 times the amount of the unpaid wages plus costs and reasonable attorney's fees. So, LLR, or excuse me, so the employer may end up being responsible for paying your lawyer if you have to hire one, or making a nice donation to South Carolina Legal Services if it's necessary to go to court. And there's a few things to keep in mind. You must bring your suit within 3 years of the failure to pay. So there's a 3-year window. If there's paychecks that were not issued, or if there were deductions to your pay, once they go outside of that 3-year window, you can't recover them under the Payment of Wages Act. So it's 3 years seems like a lot of time, but it's important to be aware that there is it can pass quicker than people realize while they're trying to do other things to get paid. So it's important to just be aware to move quickly enough to bring this lawsuit if it's necessary. The other thing is that the courts have found that owners and managers of companies, of businesses, may be sued personally for failure to pay wages if they had knowledge of and were responsible for the failure to pay. So that can have some real teeth. When I'm representing a client, if I have to send a letter to an employer and say, hey, pay my client, I will definitely mention to them that, if necessary, we'll pursue them individually, separate from their company, to get them to pay. And we'll file a lawsuit against them personally. And sometimes that gets a little bit more attention and gets a response because, you know, maybe the company may not have any money to pay if they're not, if business isn't good, but maybe the owner does. Let me see here. And then the last thing I would mention about going to court is it really is important to have an attorney. Now, it is possible to bring these sorts of claims by filing a case in magistrate court and represent yourself. And if you do that, you know, you want to make sure you have all your proof, you want to have all your evidence together, you know, you want to have your check stubs, you want to have your, or whatever evidence you have of what you're to be owed, you know, you want to have witnesses. It's possible to do it yourself, but your likelihood of success is a lot higher if you hire an attorney. And whether that be legal services, whether it be a private attorney, it's important to, whenever possible, not to go into court alone. And then the other thing that's important to note about the Payment of Wages Act is that while it doesn't specifically prohibit an employer from retaliating against somebody complaining of unpaid wages, the courts have found that it is wrongful discharge in violation of public policy for an employer to terminate an employee for making a complaint of unpaid wages. So essentially, if you complain to your employer, then and say, hey, I'm owed money, that you made unlawful deductions to my wages, the employer then goes and turns around and fires you, then you may have a claim for wrongful discharge. You know, it's always, this is challenges or challenging cases like any are, but it's, you know, that it can be done. And that does happen. So let's talk about some tips. So again, I cannot reiterate enough how important it is to talk to a lawyer. Some excellent lawyers at South Carolina Legal Services, you know, as private attorneys, our law firm does employment and labor law work, but talk to somebody who can help point you in the right direction, who can, you know, guide you and make sure that you get the information you need for protecting your rights. You know, you're definitely going to want to gather proof of your unpaid wages, right? So check stubs, time card records, whatever you have, you know, whatever the like documents you got when you were hired, whatever you have, you know, witness statements, things like that. If you're still working for the employer, or even if you're not, it's important to communicate with them in writing. Like it could be text messages, it could be, you know, it could be emails, it could be letters, but, you know, occasionally I'll have clients who come in and they have a text message from the employer saying, acknowledging they owe this money, because people speak a little more freely in text messages than they do in like formal letters. So if you get your employer to admit that they owe the money and they're going to pay it, even if they don't pay it, at least you have it in writing that they owe the money and they admit it. That can be very useful. So, you know, communicate with the employer in writing and try to figure out ways to prove that the money's owed. Now, if you're trying to recover unpaid wages after you're separated from the job and after 30 days have passed from your last paycheck or, you know, what have you, then you're going to want to send a letter to your employer demanding payment. So it could be just a simple letter saying, you know, you owe me, you know, the company owes me such and such amount of money, and I haven't received it. It was due on such and such date, and you know, if it's not paid within 14 days, then I will pursue my legal rights. It could be something very simple like that, and that's fine. And I recommend that letter, probably you should send it certified mail, return receipt, so you have proof of having made the demand. Now, why is that important? First off, maybe they'll go ahead and pay, which would be good. But secondly, it shows willfulness. One of the things that courts look at when they decide whether to award 3 times the amount of the unpaid wages is whether it's an intentional failure to pay, right? So it helps if you have laid it out to the employer why you're owed this money and how, you know, and given them a date to pay, And if then they go through that deadline and not having paid, then that increases your argument that it's an intentional, willful failure to pay, which increases your chance of getting the treble damages, which is treble means 3 times the amount. Now, this is not a presentation about the Fair Labor Standards Act, but I do want to mention it for a moment because it does touch on a lot, it overlaps somewhat with the issues that the Payment of Wages Act deals with. So the Fair Labor Standards Act is a very complicated law and has many nuances about who is covered and what companies are covered and what type of work is covered and all that sort of thing. But essentially for many employees, it says that you're entitled to minimum wage of $7.25 an hour, and overtime or time and a half for covered employees working over 40 hours a week. So oftentimes, if somebody's making deductions from your wages, that whether you agree with them or not, it might take your pay under $7.25 an hour, right? Or if you are, if you find that your boss is changing your time card so that instead of showing that you worked 45 hours one week, all of a sudden you see your paycheck stub has been bumped down to 40 hours a week, then that can be a violation of this law. Now, like I said, coverage is complicated. You know, there's exceptions for the food and beverage industry. There's exceptions, you know, if you're a manager with certain types of authority, and you may be exempted. But you know, if you think that your employer has violated this law, I highly recommend you talk to an attorney, because we can help you, or legal services can help you. Someone can help you walk through all the facts to figure out whether you're covered and whether you have a basis for a lawsuit under the Fair Labor Standards Act to try to get paid what you're entitled to. And there's also a complaint process with the United States Department of Labor that will investigate a complaint of not getting paid properly. And they're a little bit more, they have more tools at their disposal to enforce the wage laws than the state Department of Labor Licensing and Regulation. So the U.S. Department of Labor can be very useful to employees to getting paid what they're owed. So I've included a link for making a complaint there. So that is that's a big overview of primarily the Payment of Wages Act with a little bit of the Fair Labor Standards Act mixed in. And you know, this time, I guess, Susie, or if there are any questions, I'd be glad to take some.
Well, I think you may have covered a couple of these questions, but one was, if the employer tells you to wait to cash your paycheck, what do you do?
Well,
do you go ahead and cash it, I guess is the question. Do you go ahead and cash it, or do you?
I mean, I guess it depends. Yeah. I don't think once they give you your paycheck, you have a right to cash it. What I would do is I would cash that check, and if it bounced, I'd take it to the solicitor's office and let them prosecute the person, because it's illegal to issue a check that's not good payment, right? And post-dating doesn't really get around that. So that would be probably my advice to that. And I would also be looking for another employer, because businesses that do that are probably, you know, on the verge of going out of business, or, you know, having some major problems, and that's not what any reputable employer would do.
Yeah, and I think the other was regarding that it's a violation to punish an employee for filing a claim, and I think you covered that as well. And that is looks like all the questions that we have.
If I was considering a client's case who had been terminated for making a complaint of unpaid wages, what I would like to see is that they made a very clear written complaint, right? Either to directly to the employer, you know, it's very clear that what they're owed and why in writing, or to the, you know, the LLR or the U.S. Department of Labor. So I would say if somebody's in that situation, think about think about me, think about the lawyer that's looking to figure out whether there's a claim. You know, is there proof that they made the complaint, clear proof? And so I'd say, you know, sending that complaint in writing by email, or, you know, or letter, or anything else would help us have what we need to show that that was the reason for the discharge, right? And there was retaliation. So people don't always think that out about how, you know, a conversation with the boss about not getting paid right is a little harder to base a lawsuit around, because we don't have, you know, so oftentimes don't have corroborating evidence to support the, you know, that conversation. You know, maybe if there wasn't any other witnesses or what have you, it'd be much better to have like an email or a text message or something like that, where we have it locked in that the conversation, that there was a communication about wages.
Right. Well, this is such good information, because I'm sure that folks out there who are employees, as you say, it's a difficult conversation to have with the boss when they're not doing things right, whether it's you know, overtime or pay or any of the other stuff that you have mentioned. So it's really helpful, I think, for people to know about these rights and, you know, what they can do when it happens to them. So listen, thanks so much for such a great presentation. And I think our listeners or viewers can see here the slide that has all of our contact information here at South Carolina Legal Services. So you can apply online. You can call our intake line. So both of those are great ways to contact us. And I would also, you know, urge you to, as Jack said, if you're not eligible for us to help you out, private law firms like Burnett, Shutt, McDaniel, where Jack is from, are the way to go, because as Jack said, you definitely do need a lawyer when you have one of these situations and you're looking at needing to file a lawsuit. I want to also mention our social media. You can see our websites, our social media handles. All of those are here for our viewers to check out for all of our resources. And I do want to remind everyone that if you found Jack's presentation helpful, which I'm sure you did, you can go to our YouTube channel tomorrow and share it out with people that you think it might be helpful to, besides yourself. And, you know, we want as many people as possible to get good information that we put out on Level Up Law, like this information today about the Payment of Wages Act here in South Carolina. I did also want to mention to our viewers that tomorrow, December 7th, South Carolina Legal Services is hosting a virtual event in conjunction with some of our partners in the elder law area, how to recognize and avoid holiday fraud, theft, and scams. Don't let the Grinches steal your holidays. So you can definitely go to our website. You can see it here on the screen, sclegal.org, and register for tomorrow's free, of course. And I definitely recommend it. We have some great speakers from the Department of Consumer Affairs, Department on Aging, the Secretary of State, ORS, Office of Regulatory Staff, the Better Business Bureau, and also South Carolina Law Enforcement Division. So we'll be looking at all kinds of different topics that may affect you not only during the holidays, but throughout the year, but they're especially bad during the holidays. So definitely check that out. And I also just want to remind everybody to tune in next week for another episode of Level Up Law on Tuesday at noon. We'll have our Public Benefits Unit Head, Jenny Kaufman, and she'll be discussing, this is a rescheduled show. She could not be with us when she was originally scheduled. She'll be discussing the recent adjustments to Social Security benefits. So that promises to be a good one. And that's all we have for today. I do want to thank Attorney Jack Cahoon, employment law attorney from Burnett Shutt McDaniel. Their office is in Columbia, South Carolina. It was an excellent presentation, very informative on such an important issue. And I also want to thank you, our audience, for joining us not only today, but each week here live or later on YouTube, either one. And so, Jack, again, it's good to see you. We miss you, but now you're doing great things there as an employment lawyer at Burnett Shutt McDaniel.
Well, Susie, miss you too, and please tell everybody I say hi.
All right. And thanks again, everyone, for tuning in today on Level Up Law. That concludes today's webinar. Take care, everybody.